Let's bring in our think tank tonight and start on that note. Joining us in Atlanta, Georgia, criminal defense attorney Michael Bixon is with us. Also in Atlanta, criminal defense investigator Charles Middlestat. And in Lilburn, Georgia, municipal court judge and criminal defense attorney, the Honorable Tiffany Porter. All right, welcome you all. Judge, let me start with you. Do criminal defense attorneys set appellate traps during the trial? Like, I'm going to do something, I know it's wrong, but you know what? We could use this later on just in case the jury doesn't agree with me.
Well, I think it's some strategy. I would not say that they're doing anything illegal. We as defense attorneys, we have to do whatever we can for our client. And if that is leaving a door open or a possibility of leaving a door open that could help the client, then I don't see anything wrong with it.
Hey, Charles, I know you know this case inside out. We covered it 4 years ago. How important, give us an idea of how important this memory expert was to the case, the expert witness who the defense did not call because of the judge, they say because of the judge ruling in the information they would have had to hand over or did hand over that he would have been cross-examined on. How important was this witness for the defense?
I think he was incredibly important. I mean, Dr. Diamond is the gold standard in this sort of testimony, in this sort of science. So his testimony would have carried a lot of weight. And, as you said, we covered this gavel to gavel. I've spoken to Maddox about the case. I've spoken to Carlos about the case. They were supremely confident in their defense, and this was a key component of it. And so the decision not to put Dr. Diamond up, I think was very, very significant, and obviously not a decision that they took lightly at all. So although the prosecutor made a very compelling argument for this so-called trap, I honestly, based on my conversations, I don't think that to be the case.
Michael Bixon, another part of this whole thing is they're saying ineffective assistance of counsel. I mean, you practice down here. These are great attorneys, right? Very successful, very revered, very expensive. I mean, everything.
I mean, they're absolutely great attorneys. I mean, some of the attorneys that you had on this case were some of the best that money could buy, without a doubt, okay? That being said, when you're ever going to do some type of motion for a new trial or appeal, and you're going to claim ineffective assistance of counsel, it happens all the time. I mean, look, no matter how good or how bad an attorney is, they all make mistakes. That being said, whether or not there actually were mistakes on the defense's part here, I think is certainly questionable. I think the defense did a great job with the rules and the parameters that were set by them by the judge. And I think there are definitely issues that are appealable here because of what the judge ordered, definitely pre-trial here. So, how effective the ineffective assistance of counsel argument is going to be compared to some of the other arguments, I think time will tell.
All right, another big part of this case were surveillance videos of the parking lot where Harris parked the car. And at lunchtime, some buddies picked him up and they went, I guess, out to lunch and stopped at the hardware store. And I guess he got the idea that he needed to buy some light bulbs. So he bought some light bulbs and then they dropped him off at his car, not at the front door of his office. And he opens up his car door, puts the light bulbs on the passenger seat, and then closes the door and goes back to work for several more hours. Well, today, Brian Lumpkin, defense attorney, who represented him at the trial, testified about that.
I'm referring to the fact that the residence, the Harris residence, had some light bulbs that needed replacing in a bathroom, as I recall. And Mr. Harris had bought bathroom bulbs that matched those exactly on the day of this incident. And so to the extent that we were trying to show that it wasn't some made up reason to get light bulbs just so he could go to his car and check on how things were going, as was suggested by the state and refuted by the evidence, in my opinion, there was an actual need for the bulbs, and he got them and he placed them in the car without ever getting inside the car.
Yeah, Charles, one of the issues people had here was this lunchtime visit. Like, some people had the theory that he was opening the door and was going to put on a show in front of his friends about, oh my goodness, finding his son. These are the people who believed he murdered the child. Oh my goodness, I found my son in the car. But when he was dropped off, they drove away before he could do anything. So explain to us how it's possible that he's got light bulbs in his hand, opens the door, and he's got that little mini SUV, not a big one like you do, Charles. He's got the mini SUV, right? And tosses the, or puts the light bulbs on the passenger side and doesn't see the car seat, doesn't see his son's head, and doesn't smell anything.
Well, this, in fact, is one of the issues. We debated this vigorously, I recall, during the live coverage of the trial. But also in the 3D reenactment, I think the defense takes exception to the way that was handled and the admissibility of that particular rendering. Listen, it's hard to recreate that. I'm skeptical. I think that sort of evidence actually points to the contrary. I mean, if you truly were premeditating this, then why would you go check? And you don't need your friends there to make a big spectacle. He was parked just feet away from the entrance to his work, and he could have very easily walked into the lobby and been hysterical and made some big production there. So this was never an issue that I put a lot of weight into, but evidently the jury did, and certainly a lot of the pundits out there put a lot of analysis into that and a lot of meaning into it.
And when you say pundits, you're talking about me, aren't you, Charles?
Well, you're one of them.
Yeah, exactly. See? Judge, your thoughts about opening the door to your little mini SUV, your sport SUV, and you don't see, and this is a big point, like the big argument was he's tall, he opened the door and just without looking inside the car, just toss those light bulbs in, because that's what you do with light bulbs is you want to throw them across the car. Does that sound reasonable?
Well, what's unreasonable is that you want the jury to get in his mind, and you want, we're looking at the mens rea, and you want the jurors to figure out what was he thinking. I mean, that's where it all comes down. Did he go in the car to actually check, and he saw that his son wasn't dead yet, or did he really make a mistake? And it just all comes down to his the mental state. And I think that's very hard. It's very challenging to prove or disprove. But that's what we're dealing with here is the mind and the mental state of the defendant at the time of when everything happened.
Michael Bixon, you might be the best one to ask this question to because you're, what are you, like 6'10"? How tall are you?
6'5".
6'5". He's tall, okay? Have you ever opened the door to your vehicle, whatever it is, your head is clearly above the vehicle because you're very tall, and like put something in and not even looked in the car?
All the time. I open up the door, throw whatever you got in to throw in the car, and you walk away, and that's it. I mean, look, there's nothing. You can draw out a conspiracy whenever you want to. I do not think this is one of the situations. The guy opened his door, threw what he had in the door, and walked away, and that's it. I mean, certainly you can paint a picture of whatever you want out of that. But to me, it's as innocent as it looks. I mean, the guy threw something in his car and walked away, and that's it. Is it possible that he missed the fact that his child was still in the car? Absolutely. Judge,
were you chiming in there?
Yes, I was asking, were the windows tinted? I can't remember.
Slightly in the back. The back windows were tinted. The passenger and driver's side windows were not, but the back windows were slightly tinted, so they were a little bit more difficult to see in there. You'd have to, I think, get up to them like that.
Oh.
In order to read meaning into this, Vinny, you also have to buy into this overall theory by the prosecution that this defendant would premeditate the killing of his son, who by all accounts he adored, just for the purpose of getting into this single kid-free lifestyle. So you have to make that big leap to even buy into the reading of this light bulb issue and the fact that there's some great significance to it.
Yeah, there you see the back windows are a little bit tinted. The side ones for the front seat not tinted, but the windows were closed. They were not open, obviously. All right.
So Benny,
go ahead. Final word on this.
I was going to say, well, those pictures, I mean, it shows that he very well could have just thrown it in the passenger side and didn't see anything else. I mean, that tells a different story when you look at the actual car and look at the windows. You know, he may not have seen in the back.
All right. Okay. Jury didn't agree, but we'll see. If there's a new trial, we're going to bring you all back here. We're going to talk more about it. By the way, Charles Middlestad is now licking his chops because we're going to talk about some of the digital evidence in this case and what exactly did it prove, and did the jury get misled by it somehow? We'll talk about that when we return.
Could you tell the judge in detail what this video depicts?
The video, and I believe it's, and I might get the name wrong, it's like Ernie Ward, and he is a veterinarian, and he's advocate for, of course, animal care. And the veterinarian decides to do a demonstration about the dangers of leaving your animal in the car. So he goes out to a car, he sits in the car in the middle of the summer, it appears to be very hot outside. And he sits there for 30 minutes. And the video is about 6 minutes long. And through this video, he's showing you times and he's showing you temperature. The temperature in the car gets to over 117 degrees, or around 117 degrees. And he starts to explain how horrible a feeling it is to be in this car. And he goes over it several times. He goes, "This is horrible." He goes, "Imagine if you couldn't move, if I wasn't a thinking person, I could reason through this, that if they were just trapped here in this car."
Now, this video, was it something that you, looking from your examination, that he had viewed once?
No.
How many times did he view it?
He viewed it twice.
And Detective, what day did he view this video last, according to the examination of that computer?
According to our examination, he viewed it on June 13th, 2014.
5 days before the child's death?
That's correct.
All right, so 5 days before he leaves his son in the car, Ross Harris is watching this video done by a vet talking about the dangers of hot cars for pets. We've got a couple of pictures, still frames from it. There's the vet, and you see him outside the car, and then he goes inside the vehicle, and he's got this big old thermometer showing how hot it gets, how quickly. It was a very powerful video. Ross Harris watched the thing twice, 5 days before he left his son in a hot car. Now, Carlos Rodriguez, who was one of the great attorneys who represented Ross Harris during the trial, testified at the hearing about this issue. Take a listen.
This video on YouTube that was a veterinarian doing a demonstration about how hot it gets in a car, and reminding folks not to leave their pets in the car when they, go shopping.
So it was a like a public service announcement, or is that what y'all were calling it during the trial?
Yes, sir. He did not research or search for how long it takes for a child to die in a car, and he wasn't actively researching hot cars or children dying in cars or children dying or anything of the sort. It was basically a video that just popped up on his feed, or that he was redirected to after some post on Reddit.
All right, let me bring back in the think tank. Michael Bixon, do you head out to Vegas at all?
Not too often, Vinny.
Okay, well, I'll ask you anyway. What are the odds of someone watching a video twice about the dangers of hot cars, then 5 days later forgetting his son in the back of a hot car?
I think it comes down to whether or not, one, did he search this video? Two, did he actually watch this video from beginning to end twice? Is it something that just popped up and he just clicked on and it played a little bit, closed it out, opened it back up, started playing again? And whenever you're talking about any type of digital evidence or something like this, and nowadays with the algorithms and the way they change, it's absolutely possible that he accidentally, left his baby in the car after maybe watching a part of this and after he didn't search it. So for them to come in and later on introduce this as evidence against him, look, I get it. I understand why they would, but there's definitely holes in terms of, how he looked it up. Did he look it up? Did he actually look at this thing twice?
Charles Middlestad, you know how powerful digital evidence is these days. It's the foundation of many of the cases that we cover here on Court TV and that you investigate. Is this misleading digital evidence?
Well, potentially. I mean, again, you have to look at it in its totality, vis-a-vis the other evidence in the case. And certainly from the prosecution's standpoint and their theory of the case, it makes perfect sense that they would highlight this fact. But as Michael said, the thing that digital evidence can't always tell you are the circumstances surrounding that. And this is very different than someone who, explicitly enters a search into a browser for, how long does it take for an animal to succumb to heat in a car or a child or anything else. That just didn't happen. There's no question. I mean, it's unrefuted that this popped up on a feed and that he watched it. And again, as Michael said, we don't know whether he just clicked on it and then abandoned it and walked away, made himself a sandwich, or how that took place, or if he watched it with great intent. We just don't know. So, the skeptical mind will certainly view this in a very suspicious light and go, what are the chances? What are the Vegas odds on watching that and then 5 days later he forgets his kid in the car? But again, it's circumstantial in nature, but you have to put it in the context.
All right. Judge, I want you to listen to Carlos Rodriguez here talking about another post. This isn't 5 days before. This is the day of. This is the day Cooper dies. This is from the morning where he responds to a post about hating being married with kids. Let's listen.
You mentioned that I hate being married with kids, that paraphrasing of that whisper image. Was that found to definitely not be sent by Justin Ross Harris?
Oh, definitely. Yeah, it was definitely not him.
Okay. And all right. So, and that was one of the tasks that Mr. Persinger did. Was Ross ever attributed to a follow-up to that comment?
Yes. He commented on it. Ross had responded to that image, or responded to the person that wrote it and created it.
Do you remember what that response was?
It was a series of responses. I think it was kind of a back and forth, but Ross was encouraging. He certainly did not suggest that he hated being married or he hated having a child. In fact, I think what he specifically said was that he loved his son. But suggested, sometimes we all need escapes, or, we all need a break or something like that.
That was, that statement was attributed to Ross.
Yeah, Ross wrote that.
And he wrote that on the Secret Whisper app. It was his app, which is kind of hidden on his phone, and it's all secretive. I've got the actual response, so we get a verbatim here, Judge. Let's put it up on the screen. And I call this the big but response. I love my son and all, but we both need escapes. Like, I can't imagine ever writing that sentence or saying those words and putting the big but in there. But what are your thoughts, Judge? Is that an incriminating statement? Is that just a vanilla statement that doesn't mean anything? Or is it something that a lot of parents say? Yeah, I love my kids and all, but I mean, we both need our escapes.
Right. I don't find anything wrong with what he said. As a mother of four, there is no telling what I've said when about my children, or just being frustrated or needing a break. I think we might read into that a little too much, but we also get down to, is it going to be enough to meet the standard to actually get a new trial? And I don't know if he has it. There's so many holes, and now that he's been convicted, it's hard to go back on those and try to point out every discrepancy, because I believe you may have the same verdict again.
Yeah, and you're trying to convince the judge that she made a bunch of mistakes at the original trial, which I think is a challenge in and of itself. At this motion, maybe you have a better shot with an appellate court. I don't know. But let's listen to more Carlos Rodriguez. There was a search that he did, Ross Harris, about what life is like in prison. And I remember that from the trial. It sounded very incriminating, and now we've got another explanation for that.
The search that Ross actually made, which was, what is prison really like? He was watching the show on Netflix, Orange is the New Black, which was a show about a women's prison.
Huh. Charles, what do you think about that?
Benny, you are so skeptical. I mean, listen, you can make anything look and sound a certain way. I mean, this butt stuff that that you love to read into. Listen, we've all, if you've ever raised a teenager, which I've raised 3 of them, there's times when you go like, hey, to one of your friends, how would you like to adopt one of my kids? How would you like to buy a child? How would you like to, take this kid off my hands? I mean, we all do and say things out of frustration. And what he said is even sort of less comical, less egregious than that. So to read into these things, I think, again, it makes sense for the prosecution to argue this because that's the thread they're trying to weave. But in isolation, each one of these things doesn't necessarily mean anything at all. And so they're not, these statements aren't that shocking. And again, there's generally some explanation for it. It's just, it only means something if you're willing to make this leap that despite the fact that, millions of people in this country engage in adulterous affairs, both men and women, and happen to have children. They don't resort to, killing their children in order to pursue those affairs and pursue, some activities outside of their marriages. It's just we choose to believe in this case, or the prosecution wants us to believe in this case, that this guy found that was the only way he was going to be able to do this in his life. And so, again, it only has meaning if you want it to have meaning.
Yeah, it wasn't just the prosecution. It was 12 jurors, too, down in Glynn County.
After 4 days and
some
evidentiary rulings that are at issue right now.
All right, well, let's do this. And we don't have any more time to talk, but just by a quick show of hands, who thinks this judge will give Ross Harris a new trial? Unanimous. All right. We'll see if we're all right. All right. When we come back, we're going to take you on the docket. A case involving a professor out at Arizona State University is allegedly lured out into some remote area for some sexual encounter, ends up dead. He's recovered in a landfill. Now 2 teenagers are facing murder charges. We'll talk about that case next. On the docket tonight, a story out of Arizona involving a professor from ASU who went missing. And there was this huge search trying to find him. They ended up recovering his body in a landfill and arresting 2 teenagers. Our affiliate, KNXV, has more for us tonight.
Deputies spending hours combing through the trash at Northwest Regional Landfill off 195th Avenue and Deer Valley in Surprise.
MCSO says strong evidence led homicide detectives here on March 29th, just 4 days after their investigation began.
They're just digging around the spots where they think the professor is.
That's a landfill employee who asked to remain anonymous. He also says detectives must have an idea of where in the valley the body came from and on what day, based on their targeted searching.
So he struck his track on the dumpings and everything. They put it in a log.
And after months of searching, MCSO has found the remains of missing ASU professor Jun-Suk Che. MCSO spent more than $300,000 and 7,200 man-hours searching for Che's body.
Several ASU students telling me they were told their professor, who has the same name, went missing in March and was later replaced. Now, Professor Che teaches several engineering courses at ASU and is involved in several research projects on brain and lung functions, even creating a wireless prototype for safer brain implants. He also holds 4 patents and has his own book.
Professor was reported missing at the end of March. His car tracked to Shreveport, Louisiana. That's where officers questioned Javian Ezell and Gabriel Austin, both 18 years old. Investigators say Che was killed near Carefree Highway and 7th Street. His body put in a dumpster that was then emptied into the Northwest Regional Landfill. Both of those teenagers are in a Valley jail on $1 million bond each. No word at this hour on a motive.
While family and friends want justice, it won't bring the professor back. An ASU coworker telling me he was an incredibly kind man, a brilliant mind, and will be missed by everyone he knew.
So investigators got information in this case, and they got information to track the body. They got information to track down the teenagers. And the question is, what happens next now? They've been arrested. They're charged with his murder. Let's bring back in our think tank. I want to begin with criminal defense investigator Charles Middlestat. Where does the defense investigation begin in this case?
Well, at the beginning, trying to either connect or disconnect these defendants from certain aspects of the sequence of this. It seems law enforcement identified them based upon the fact that foolishly they were still driving the vehicle, but for that, maybe there would not have been some sort of connection. So what they need to do is try to disconnect them from that vehicle prior to them being discovered driving it, so that there's some sort of plausible deniability, and that, again, without knowing anything about any biological evidence or any other physical evidence that may actually tie them to his body or to that dumpster or any other part of the crime scene. So it's without understanding sort of what evidence exists, it's sort of hard to know, but I would try to disconnect them as much as possible and or try to connect other folks to the use of that vehicle as well.
Michael Bixon, how much time would you spend here trying to get a deal versus preparing for the trial?
Well, I think that the two of them sort of go together. I think that if the goal is to get the best deal possible, it's done by preparing for trial and pushing it as close as you can, because otherwise, what leverage do you have? And you need, the more leverage that you have, the better the offer you're going to get. I mean, this is going to be a really tough case. Make no mistake. I mean, even if you are able to, say that they were innocently driving the car, my understanding is they made statements after, and those statements are extremely incriminating. And don't get me wrong, there's always a way around anything. But that being said, it's going to be a very, very difficult case. I think that the further that the defense attorneys work this, the more work that they put into it, the better the result is going to be in terms of whether it's a trial or whether it is actually a deal at the end.
Judge, how much information do you want to get from your client? Do you want them to tell you the truth, the whole truth, and nothing but the truth?
Absolutely. You should always be honest with your attorney and give them all of the information that they need. No one wants to be surprised at trial or something that you may have left out, find out later. I've had plenty of times where I've asked the client, did you steal this? Did you do that? No, I didn't do it. And then we get the video and they're right there on the video. So you want to make sure that you as a defendant, that you are 100%, 1000% honest with your defense attorney. So that way they can put on the proper case for you.
Charles, do you have to take any time to investigate the victim here?
Again, it really depends on some of the evidence in the case, but I'd want to know as much about the victim as I possibly could. And there's a good chance that these defendants ultimately could end up being oppositional to one another. They may have a different level of responsibility in this case. And so there's always that possibility that, one gets offered a deal and the other one doesn't, and is encouraged to testify against the other in order to secure a conviction. So, there's a lot of, this is a fluid case, and there's a lot of different ways that this could shake out.
All right, Michael, there's an allegation, and we don't know if prosecutors have the evidence to back it up, but there's been an allegation that he may have been lured by the promise of some sort of a sexual encounter, whether it's a sex for money or just for whatever reason, right? Just to do it. How would that play into the way you try the case if they're putting in evidence that there was some sort of promise for this encounter between the parties? How would you approach that?
Well, I think it depends what perspective you're looking at it. I mean, this is a very common scenario. I see it all the time play out, almost identical to this. And back in the day before, you had a lot of the apps. It would be people meeting up in clubs, being drawn outside, and then usually being robbed or something like that. And it still happens today. Nowadays, you have a lot more online meetings. People meet up and then they end up getting robbed and, God forbid, even killed. And that's something that, is obviously what appears to have happened here. Now, if I was the defense attorney in this case, and we're sort of going down that road, obviously the more input that the victim has in a case like this, the better off you are. You want to obviously try to separate your client away from any type of scheme or trap that you can, but obviously the facts can make that very difficult.
All right, we're going to continue to track this one, folks. We've got a couple of dates to show you. We've got a pretrial conference on March 11th, 2021, and then a tentative trial date for March 18th, a week later. We'll see if the parties are ready, and we'll see if they're trying cases out in Maricopa County, Arizona. When we come back, time to hear from you, the 13th juror, your verdict on the hot car death case. And I gave everyone three options. 1, guilty, malice murder, life in prison. 2, guilty, involuntary manslaughter, 1 to 10 years. 3, not guilty, set him free. We'll hear what you have to say when we come back.
The court pronounces the following sentence in the case of the State of Georgia versus Justin Ross Harris, criminal action 14-93124. As to count 1, the court imposes the sentence of as to malice murder, with the jury having found the defendant guilty. Sentence of the court is life to serve in confinement without parole.
Life without parole. That was the original trial back in 2016. So today I posted, based upon all the evidence you've heard in the hearing and what you know otherwise, what would your verdict be? Be the judge and the jury. Is it murder? Is it involuntary manslaughter? Is it a not guilty? We begin with our 13th juror comment of the day from Yvette, who wrote, I believe he intentionally left that baby in the car. Even if it was a mistake, he should be in jail for life because of stupidity. How can you forget your baby? Impossible. Michael Bixon, is there can you make a mistake and be held criminally responsible in Georgia?
Absolutely you can. I mean, absolutely. And I think that when you look at this case, it should have been involuntary manslaughter. I think that the facts fit the charge. Unfortunately, obviously, it's not what happened. And I certainly understand the viewer's comments, but from my analysis, looking at the facts, I think that's a much more appropriate charge.
Phyllis agrees with you. She's writing tonight. 2, involuntary manslaughter. When your mind is working overtime with daily stresses, it's easy to forget things we do daily. Not my place to judge him. Hard to believe that someone would deliberately leave their child in such a horrible situation. It wasn't as if he hid his car so no one would notice. Now is it? Judge, would 10 years be fair here? 10 years for Ross Harris?
I think it would. I agree with Michael that the evidence presented in the case and the circumstances around the death, I think that manslaughter or involuntary manslaughter would have been appropriate. And it would have also closed the door for any appeals.
Nancy tonight writes, if Casey Anthony can walk free, so should he. I believe it was a terrible accident. Charles Middlestat, who's worse? Casey Anthony, who was found not guilty, or Ross Harris, who was found guilty?
Well, you know how I feel about this case, Vinny. Totally different circumstances, but this was a circumstantial case. As much as we cherry picked things in the digital evidence that people choose to view as pointing towards his guilt, what the prosecution didn't talk about was the fact that he had planned a vacation, booked a cruise, got Cooper's passport in the days before. And so we sort of lose sight of that. We choose to see how we want to see this There were problems in that marriage. He had been unfaithful. There was a loss of intimacy. The one constant thing that everybody talked about was his love for this child, including his wife who testified on his behalf. So, is this tragic? Did he fail Cooper? Absolutely. Should he be held responsible for it? Absolutely. But I'm in the same camp. To me, this was always a involuntary manslaughter case. Absolutely negligent. He got caught up in this lifestyle, and he just his interest in his personal life just overruled his responsibility to his child, and he made a terrible, tragic, fatal mistake.
Objection, Judge. Non-responsive. I believe the question was, who is worse, Casey Anthony or Ross Harris?
I know, but you let me get on my soapbox, Vinny, and you knew this was going to happen.
All right, let's get to the next comment. This is Brenda, who writes, guilty of malice murder, life in prison. He remembered his cell phone and at lunch put light bulbs he had bought into his car. At that point, the baby had been in there for hours. They stopped for breakfast and drove a few miles. Actually, I think it was 0.6 miles. And in that short drive, about 6 minutes, he forgot about his son. No way. Michael Bixon, does the 6-minute drive bother you?
Not really. I mean, look, people forget things. It happens all the time. And obviously, this is a horrible case of this, right? I mean, it's terrible. Terrible set of facts, a terrible end of the story. There's nothing good about this. But as horrific as it is it possible that he did forget? Absolutely.
Michelle not agreeing with you because Michelle takes a look at it a little bit differently than I did. It was only 13 seconds after he put him in the seat that he apparently forgot about him and drove straight instead of turning to his daycare. Nope, sorry. And he went to the car in his lunch break to put something in the car, and he looked up hot car deaths on his computer. We talked about that. Sorry, lock him up. That lunch break was a big fact in this case. Does it loom large for you as well, Judge?
Yes, and just looking at all of his actions. The problem with this case is that now that he has been convicted, that this is going to be hard to get, I think it's going to be hard to get a new trial so that another set of eyes, another jury can see all of the inconsistencies that we saw, but I just don't think he's going to get there. So it's unfortunate.
Allison writes, I think it was a horrible mistake. I don't think he purposely left his kid in the car. This happens a lot, and they do give parents a lesser charge or let them go and say it was an accident. We have about 20 seconds here, Charles. Why do you think prosecutors went after him?
Just the I mean, you have no choice. It's such an egregious mistake. But I think when they learned of the extracurricular activities and the sexting and all that, I think that's when it started becoming really egregious. Listen, I wish it was impossible, as Yvette said, but unfortunately, it's very possible, and it happens. But I think his lifestyle and the fact that he's such a flawed individual is what really contributed to the initial charging decision.
Charles Middlestat, Michael Bixon, Judge Tiffany Porter, great job as always. Thank you so much. Have a great holiday if I do not see you. Appreciate it.
You as well.
All right, ladies and gentlemen, I'll leave you with this. Again, every time the hot car death case, take off your left shoe, put it in the back seat with the child. You'll never forget that baby. In the meantime, don't forget to hug your kids.